Hi, everybody. Welcome to our session today. We're going to be talking about the wonderful topic of Oracle audits. Everybody should be excited about this, or everybody may be dreading the possibility of being audited yourselves. But we're really excited to be talking to you today about running Oracle on VMware, and especially how to prepare for and how to deal with the threat of an audit. So very excited to be talking to you today. So here's some of the topics we're going to be talking about. But rather than spend a lot of time on this, we'll just kind of jump into the conversation here. So my name is Nathan Biggs. I'm the CEO of House of Brick Technologies. House of Brick is I'll talk about us later, but so I work with a lot of customers on Oracle licensing issues. I help a lot of customers in audit defense situations, and so this is something that we're doing every day. And I'm really thrilled to be joined on the stage by two people that I work with on pretty much a daily basis, trial attorneys Art Beeman and Joel Muchmore. So, guys.
Good afternoon, and it is indeed our pleasure to be here this afternoon to discuss with you, as Nathan pointed out, the world of Oracle audits. My name is Art Beeman. I'm a trial lawyer at Arent Fox, where I head the California litigation practice. I, in the main, handle intellectual property disputes and commercial matters, and I hope that what we can achieve this afternoon is Joel and I at least providing you with the lawyer's perspective on these disputes, because at the end of the day, words have meaning in contracts and licenses, and it's the obligation and responsibility of lawyers on behalf of their clients to craft the appropriate interpretation and meaning of those words. And you'll see how whatever those words ultimately mean can really turn a dispute inside out.
And briefly, I am Joel Muchmore. I am also a partner at Arent Fox, and I work with Art in the complex litigation department, and I am also a trial attorney. But most importantly for our next hour or so here is I spend a sizable amount of my time representing Oracle licensees in the trenches, squaring off against audits, license disputes, and on the occasion that it is necessary, filing suit and going to court on their behalf. So that's basically the capacity I'm here today, and looking forward to talking about this.
Thanks, Art and Joel. And just so you know, we'll be getting into this a little bit, but Art and Joel were the attorneys that represented Mars Corporation in the now famous Mars versus Oracle. So we have I can't call you experts, we have
About legal.
The key legal team here that know the ins and outs of dealing with Oracle. All right, so just a little bit about House of Brick. We've been around for almost 20 years now, and started out as an Oracle team focused on scalability, performance, right sizing, things like that. But over the years, we added expertise around SQL Server. We added expertise about 11 years ago around VMware. And then recently, in addition to all these other things that we do, perhaps our most in-demand service right now is license services, because everybody is trying to deal with Oracle when it comes to running your Oracle software on a VMware environment. Now let me say this, and you may hear me say this a number of times. We love Oracle technology. The Oracle software is terrific. We love it. What we don't love is how Oracle, the company, treats their customers. And so that's where we try and help our customers to know what's right and to defend themselves against some of the overreaches that Oracle has.
Arent Fox is a general service law firm that was founded right around 1942 in Washington, D.C. It has expanded to New York, Los Angeles, and recently San Francisco. And in fact, Art and I were the original partners hired to take over and found the San Francisco office. There is a lot of IP that is done, a lot of litigation, and a lot of that similar work. But again, what we are here to talk about is the Oracle practice that Art and I have basically founded out of the San Francisco office, which includes in almost every instance, there are details, there are unique factors for every Oracle dispute and every Oracle audit, but it starts with VMware. It starts with an Oracle licensee that is running virtualized clusters and servers, primarily almost always VMware, and then that becomes the springboard for how the rest of the dispute, how the rest of the matter goes forward.
And we are, I believe, in a unique position here to talk to you about, as Nathan referred to, the Mars v. Oracle case, which has achieved its own notoriety within the technology world. And what Joel and I would like to do in the time that we have here is show you how, through publicly filed documents, everything we're talking about is a matter of the public record. But we want to walk you through a portion of that public record so you can see how the dispute unfolded and then how it was ultimately resolved. This was not a matter that went to extended or protracted litigation, but for just the brief life that it had, it provides, we believe, for licensees around the world, a window into the tactics and strategies employed by Oracle or in these licensing matters.
Thanks. So why virtualize Oracle? Really, virtualizing Oracle on VMware is becoming a best practice. This has changed over the last few years, where 5 years ago it was people were a little bit nervous about it, worried about performance and things like that. All of those concerns have gone by the wayside. And now it's become a best practice to virtualize Oracle on VMware. Now the issue is licensing, and especially because Oracle is reaching beyond their contractual bounds to make claims on customers that just aren't fair or true. So the advantage is you really need to, if you have the opportunity at all, you need to talk to your organizations about virtualizing Oracle. Don't leave it on hardware anymore. You need these advantages of cost reduction, of optimizing your licenses. Once you license a VMware host for Oracle, you can stack as many virtual machines on there as you want running Oracle without incurring any additional license. So high availability is great, recoverability, optimizing the development process, test QA is enhanced with VMware, flexibility in deployment. If you want to do private cloud, if you want to do a hybrid public cloud, that flexibility that you get with VMware is just unmatched compared to if you're running on hardware. And even the security enhancements. So these reasons are really important considerations for your organization to virtualize their Oracle software. And we'll talk about the licensing thing, which is kind of the last emotional hurdle that people have, and sometimes even beyond emotion to the bottom line if Oracle gets involved in trying to claim fees due when they really shouldn't. So we'll talk about this Oracle agreement and some of the factors here. So there's a key phrase that you need to understand that's in all of your agreements. Yeah, whether it's a really old SLSA or whether it's an OLSA or a newer Oracle Master Agreement, OMA, the phrase is, processor shall be defined as all processors where Oracle programs are installed and or running. So, installed is a past tense, but currently applicable term. It has been installed and it's still installed. Running is present tense. There's nothing in the definition of the word processor in your contractual binding agreement with Oracle that says you have to license something where it could run in the future. It's only installed and or running. So when Oracle tries to tell you that you need to license something for what may happen, that's not in your contract. What may happen is you may move a virtual machine onto another host that doesn't have a license. Okay, if that happens, you have to have a license for that virtual machine. But you don't have to have a license for something that may or may not ever happen. So that's the definition that's really important for you to remember. I'd like to hand it over to Art and Joel now, or to Joel, to talk about another clause in the contract that's really important for you to understand.
Well, and then what is important is, as Nathan identified, is that basically think of everything as being in two tranches. It is either part of the agreement or it is not part of the agreement. And that seems very rudimentary, except for when you interface with Oracle, they will fling a lot of documents, a lot of information, a lot of things on the web and say, well, this is where we derive our authority from. but it's not part of the contract. It's not part of your policy. It's not part of your license. Now, for putting the lawyer's hat on for just one moment, here is why that is important, and it is what we call in law an integration clause. What it basically means is every obligation you have is integrated into this contract, the four corners of the document, and that's all that you need to worry about. And the typical integration clause says, and I'll just pull a few of these main words out, you agree that this agreement, together with the applicable ordering document, are the complete agreement for the programs and or services ordered by you. So remember that next time that you are being told by somebody at Oracle, and as Nathan is going to walk through in a moment, about the partitioning policy or the cloud services policy. Those were not attached to your agreement. They were not referenced in your agreement. They were not agreed to by any Oracle licensees. They were something that was manufactured often after the fact or ancillary to the fact, but they're not part of your agreement because they are not integrated in from this integrated clause. So there's your brief legal seminar on why it is that they can't pull something off the web and then say that binds you. You are bound by the contract and the contract only.
One point to underscore that Joel made, don't then fall into the trap of, by virtue of your conduct or your communications, to appear then to have adopted something that was not part of the contract, and then by virtue of the course of conduct, it becomes part of the contract. And that's why, to Joel's point, it is so important that the bifurcation, the separation, is recognized and then honored.
That's a great point, Art. We see that all the time where Oracle, sometimes the customer will go to Oracle and say, I'd like you to give me an extra agreement that allows me to run my Oracle software on VMware. Well, asking for Oracle for an extra agreement opens the door for them to put a lot of restrictions on you that you don't have. You already have the privilege of running Oracle on VMware. Why would you ask for something additional where they can open the door to putting more restrictions on you? So stick to the contract and don't worry about what's not in the contract. So let's go to this next slide that kind of gives a summary of some of the things that are in your contract and things that the documents that Oracle has that are not in your contract. So things that are binding, that you have already agreed to. The technical support policies, the processor core factor table, the ordering documents, those are contractual elements because the contract references those things. And so those are a part of your contract that you must adhere to. There are things that are not referenced by the contract, but they look nice. The Oracle formats them very, very professionally, and they'll show them to you and say, look at this professional looking document. Specifically, the partitioning policy document says you can't use VMware to restrict the number of cores that you pay licenses for. Well, that's a very nice looking document, but it has nothing to do with my contract. So please don't bring that. The entire agreement clause that Joel was referring to excludes the partitioning policy document. And yet, Oracle tries to use that. At the bottom of the document itself, it says, this document is for educational purposes only and may not be included in any contract. It is not part of your binding agreement. So let's jump in and talk about the audit, because that's why you all came, to understand about the Oracle audit. So let's first talk about some of the things that you have already agreed to. You have already agreed that you can be audited by Oracle. So let's talk about some of those things. So what is an Oracle audit? This is out of a reference from the OLSA that we have a link to in there. Oracle has the right to audit you according to your master agreement. They say in there, upon 45 days written notice. Now, some of you may have negotiated longer terms. We've seen customers that have negotiated 60 days or so forth. But generally, you have 45 days. Oracle's going to want you to complete the audit in 45 days. You actually have 45 days to even respond to their notice. So we'll talk about what this means and some recommendations we have for you. You have already agreed that you're going to cooperate and provide assistance at your own cost. And then also Oracle typically agrees in these contracts that the audit will not unreasonably interfere with your normal business operations. Where that might come into play is if you're in the middle of a massive migration, for example, and Oracle says, hey, we're here to do an audit. you can say, we cannot do an audit right now. We're in the middle of a massive migration. We cannot stop and do an audit. So that would unreasonably interfere with my business. Please go away and come back another time. And they're pretty reasonable about doing that. But that's in your agreement. You also agree that within 30 days of written notification of fees due, that you would settle up. Now, Oracle will also try and accelerate your activity within this 30-day. Let me tell you this, we have never, in our history at House of Brick, seen an audit report from Oracle that was correct the first time. They have all contained errors. False positives, mathematical errors, whatever it is, there are errors in there. Oracle's going to tell you that 30-day clock starts right when they hand you the report. No, the 30 days really happens when you certify that report is correct. So don't worry about trying to do something too fast. Take your time and don't try and be bullied into things. Now, if you don't adhere to the contract, if you don't adhere to the audit clause or the privilege, then Oracle has these rights built into your contract. It says that they may end your technical support, or they may terminate your licenses, or they may terminate the whole agreement. So Art and Joel are going to talk about how this applied in the Mars case and what Mars did about that with the help from Art and Joel. So typical audit triggers, bottom line, VMware is an audit trigger. If Oracle finds out that you're running on VMware, really good chance that you're going to get an audit notice. You don't have to tell Oracle, by the way. You don't have to tell Oracle you're running on VMware. If you know, I don't know if you've experienced this, but sometimes the Oracle rep will show up at our customer's door with a couple of boxes of pizza. They'll say, hey, we're just here to do a nice, friendly meeting. Hey, DBAs, why don't you get in the room? We brought some pizza. And everybody's sitting around the conference table, and the Oracle rep says, hey, what version are you guys running on VMware? What version are you running on? They're doing some fact finding. So it's really important to control information. To help your DBAs understand, they shouldn't overshare with Oracle. Now, I probably should have put this slide a little bit earlier. You may have seen this before. It's the Oracle parking garage. This is the Oracle mentality when it comes to licensing. The guy's coming out and he says, $1 million to park my car? And the Oracle parking guy says, well, we had to charge you for every spot since you could have parked anywhere. So that's the mentality that Oracle has about licensing, that because you could run a VM anywhere, you have to license every VM host. That's just not true. You have to license, as we said, where Oracle is installed and or running. So some of the typical audit triggers that we see, this is an anecdotal list. There's no set list of triggers. This is just from our experience at House of Brick. What we see is that, you know, if Oracle discovers you're running on VMware, that's a pretty good indication that you probably have an audit coming sooner than later. If you're hosting proprietary applications and Oracle finds out that you don't have a hosting right, that could trigger an audit. If you have considerable organizational growth or M&A activity, Oracle seems like they pay attention to the trade journals and public filings and things like that. If you have some acquisition activity going on, they're likely to show up and say, hey, you had an acquisition, we need to check and see what's going on with your licenses. If you request access to Oracle's LMS audit scripts, which they'll probably give you, but then they'll say, you know, if you're wondering if you're in compliance or not, we're going to help you check to see. If you reject an Oracle proposal for additional purchases, so, you know, if the sales guy is trying to pressure you end of quarter, which is where we are right now, end of year, something like that, and you say, no, I don't want to make that purchase, decent chance that you can get an audit notice. Rejection of Oracle's bid in a RFP process. This was something, I don't know if you saw the article of a company in France that they opened up an RFP process, Oracle bid, and then Oracle lost to somebody else. As soon as they got the notification that they lost, Oracle turned around and filed an audit notice. Certifying off of an unlimited license agreement is something that could trigger an audit, and also communicating usage of features that you may not have licensed. If you open an SR for a certain feature support or something like that, and you don't have those licensed, good chance that Oracle will pick up on that. Some of the things that the conditions where Oracle seems to avoid an audit, and by the way, avoiding an audit is not necessarily a good thing. So if you have software update license and support fees that are above market, and I've seen this where Oracle is charging really outrageous support fees to customers, they tend to leave you alone. If you make considerable new purchases every year so that you have a revenue stream going into Oracle, a lot of times they will avoid an audit because they want that revenue stream to continue. If you're on an unlimited license agreement in the middle of a ULA, a lot of times they leave you alone. And then if you're using Oracle Cloud and Oracle hardware for significant workloads, they also tend to not audit. Now, avoiding an audit is not good because it probably means you're paying too much money to Oracle. I was on the phone with a CIO of a Fortune 500 company, and I asked the question. I said, "Hey, Mr. CIO, when was the last time you got audited by Oracle?" And he said, "Oh, we don't get audited by Oracle." And I said, "Oh, that's good." I said, "In our experience, if you're not audited by Oracle on a somewhat regular basis, you're probably paying too much money." He said, "No, that's not true. Oracle's a great partner of ours. They love us. You know, they bring us up at Oracle VMworld and stuff like that." I said, "Oh, that's good. I'm glad you have a good relationship with Oracle." And so we kind of continued with the call. The CIO didn't say a word for the rest of the call. At the end of the call, he came back on. He said, "I've been thinking about this the whole time. You're right. We're paying too much money to Oracle, and that's why they're not auditing us." So Dave Welch, my colleague at House of Brick, he went in and did an analysis for them, found an immediate $30 million that they could save out of their annual expense with Oracle. And as soon as they realized that, then Oracle turned around and audited them. So it's like a badge of honor if you get audited.
So we're really not talking about avoiding audits. We're talking about finding audits and finding $30 million, right?
Yeah. All right, so Mars versus Oracle. Let me turn it over to my colleagues here, Art and Joel, to talk about this case.
It's often the view when we see words fall into emails and documents and contracts to view the words then as static. In a manner of speaking, they just die on the page and they mean what they mean and life goes on. One thing you learn in handling disputes such as Mars v. Oracle is that it's actually just the opposite. And what you find especially intriguing about what happens to words when they land on pages and what they mean is that words in the technology world mean one thing, for instance, in a lot of these licensing agreements and forged in the late 90s, early aughts, and they meant one thing before, let's say, VM virtualization technology, and then along comes a new technology, and you can see this occur obviously in many spaces in the technology world. All of a sudden people are struggling with, well, what do the words mean now that this new technology has appeared? And this was very much at issue in the Mars v. Oracle matter, which, as we stated at the outset, is the only publicly filed complaint against Oracle as it relates to their attempts to control a customer's use of virtualization.
And by the way, Art, as far as we know, and you can help validate this, there has never been a time when Oracle filed a suit against a customer over this issue.
That is absolutely our understanding. And I think that just the highlights here of the procedural history of the case, you can see that there was a period, and again, this is all from the publicly filed documents, that there was extended negotiations which failed. And then what Mars did when the termination date was upon it, with only 2 days before the license agreement itself was going to terminate per Oracle's threat, filed a complaint for what's called declaratory relief. And that's important here because it's through that form of complaint, that kind of filing, that basically you go to court and you say to the judge, look, we have these words which landed on pages some time ago. We now have this set of facts related to this new technology. We want you to decide what those words mean. Obviously, when Joel and I went to court, we set forth Mars' position as to what was the plain meaning of the applicable language and resisting the tortured construction of language, which we're going to highlight shortly, that was being proffered by Oracle for simply purposes of trying to capture a new technology, in this case, the virtualization technology. That filing, we believe, by itself represented such a threat to Oracle's practices as it related to the licensing that there was an agreement to immediately stay the matter, which means it's just suspended. And then eventually there was a settlement and it was dismissed with prejudice less than 2 months after the filing. For those who are aware of the normal course of litigation, for any filed litigation to end after 2 months is nothing short of miraculous. So.
And one thing that we want to underscore about this section where we talk about Mars v. Oracle is that all of the information here is in the public record. This all comes from the complaints that were filed, some ancillary papers that were filed at the time. And that in and of itself is important because I think that throughout the country and the world, there was kind of a lot of rumbling, but not a lot of consensus as to what was happening with these Oracle audits. I think, to put it very simply, a lot of people were silently suffering. And then so when this matter was filed, then became the only public matter, a lot of people saw themselves in what was happening and realized that perhaps this was a lot more pervasive and it was perhaps even not necessary to suffer silently anymore. At the outset, what is interesting about the facts as they were laid out in the complaint, as alleged by Mars, is how uninteresting they really were. They had a 1993 legacy agreement, a license and services agreement, and of course, over the ensuing quarter of a century, it was modified by multiple ordering documents again and again and again. They nested very deep. Some were ancillary, some were aside, some were stacked on top of each other, but it had gotten quite complicated over the years. But what never changed was, one, Oracle's contractual audit right. They had the right to audit Mars's use of the Oracle programs. Users, the people who were able to use the license, were those individuals who are authorized to use the programs, regardless of whether the individuals are actively using the programs at any given time. And then back to the key language that becomes the read for which all of our Oracle's argument lands on is, again, the processor metric. Per the ordering documents, the processor and count included processors on which the products are installed and or running. And that basically becomes the pivot point, is how installed is defined. And as Art's going to tell you, they perhaps stretched credulity.
Well, now, I'm going to put on my Oracle hat. And
do you have one of those?
I do. It prevents sunburn. So let's see if we can have the best understanding possible as to our adversaries' arguments in this litigation, bearing in mind that Joel and I come to the table with the legal arguments and the legal arguments that we believe are most effective for our clients. And so here now is the Oracle argument, though not a client, the argument that we heard at the time. Central, as Nathan pointed out, to Oracle's position is the audit requests. And in that audit request, which at times no doubt can be onerous, if not downright threatening to a business, we, Oracle, demand that Mars provide a list of all clusters and servers included in Mars VMware environments. Okay? And then to justify that sort of expansive request, we, Oracle, focus on the language, as Joel pointed out, my worthy adversary, installed and or running. And Mars must purchase licenses for all processors where the Oracle programs are installed and or running. The important word here, so Oracle would say to Your Honor, is installed. and installed as it relates to a new technology, VMware technology, and the phenomenon of live migration. Because, of course, VMware technology is specifically designed for the purpose of allowing live migration of programs to all processors across the entire environment. So what you get out of all that, as the Oracle lawyer, I will tell you, it is available for use. That becomes then the box in which you place the meaning of the word installed, because Oracle programs, and this is a direct quote from documents filed by Oracle with the court, are installed on any processors where the programs are available for use. To my point earlier, new technology, you go back to the word installed, you wonder, okay, what can we argue installed means when this word was written into a contract before this technology was even available? Well, we just simply say installed was, quote unquote, available for use, and that's sufficient. And the Mars position?
How did I get to be so lucky as to take the Mars position on this one? Mars, the hat I am wearing right now.
That's because Art looks a little more threatening.
Over 250,000 pages of documents in response to the audit. Mars was very responsive, went deep, produced and produced and produced. There were multiple rounds of requests, and Mars was very compliant in going back and, as they outlined in their complaint, and grabbing more documents and sending them forward and sending them forward. However, at one point, they finally kind of drew the line and said, no more on our VMware environment, because actual use is the proper metric. It is not available for use, it is use. And to add my own little rhetoric on this, what we need to do is split between what is a theoretical reality, i.e. that it could be used on any one of these processors, and then introduce what I will call the actual or practical reality, and that goes through the disabling of live migration, and we hear this a lot. Mars had specifically gone through, and those very capabilities that Art was talking about on behalf of Oracle, i.e. the fact that it could theoretically bounce between every different processor, was specifically disabled. It could not do that.
So to put that in VMware terms, that's using host affinity rules, anti-affinity rules, the must rules, things that prevent a virtual machine from leaving a licensed host. So that's where it's disabled. They contain that software onto machines that are licensed.
And so to put that in the terms of Nathan's parking garage metaphor, it is like driving into a parking garage where all of the other spaces are blocked off and you cannot park in them. You can only park in one, but then Oracle is still saying, well, there are lots of different slots here. And then again, practical reality, couldn't park in them. Could not physically get your car in any other slot right now.
You could remove the barriers and park your cars.
But what about the video evidence? So Mars actually took video evidence of how there could not be live migration. They pulled this together and they submitted it to Oracle, and therefore said the audit is done. I mean, we are no longer going to give you any information because we have given you screenshots of all VMware clusters that use the Oracle software. We are done. We do not need to go deeper and show you more information about our virtualized environments.
The real weapon of choice here for Oracle, and we've seen this manifest itself on a multitude of occasions on behalf of our clients, and including in the Mars case itself, is the notice of termination. And this reared its ugly head, frankly, during the Mars matter, and was employed by Oracle to apply maximum pressure on Mars. As you can imagine, a major company dealing with the possible termination of a service provider, a software provider like Oracle, to where upon termination you become instantaneously an infringer of their intellectual property. That is a huge threat. And Oracle's notice is spelled out here and again, publicly available documents. If Mars continues to refuse to cure the breach, then Oracle will terminate its license agreement with Mars on October 26, 2015. Should Oracle terminate the agreement, Mars will be prohibited from all further use of the Oracle programs. You can imagine how, on the surface at least, how disruptive that sort of position being taken by Oracle in the dispute was. The termination date during the course of the Mars v. Oracle matter got pushed out a little, never by much, because obviously they wanted to keep the pressure on. And again, to reinforce the point, it's there. Oracle knows that that particular sword can be employed, and when they bring it out, being prepared to deal with it. However, it needs to be dealt with appropriately for a client, given the facts, whatever they may be for that client, is absolutely critical in the management of the dispute.
All right. So, did we skip something?
Well, no, we didn't. My bad. The one thing then to bear in mind, as I said at the outset, then the suit was filed on behalf of Mars in the face of that termination. That was the response that we felt was most effective for Mars. We've handled it differently for other clients, but forcing the issue to court and putting Oracle's definitions, tortured as we believe they are for the keywords there, installed and or running, resulted then in the quick and expeditious settlement of the matter.
Okay, so just for non-lawyer, those of us here who are not attorneys, so Mars was threatened with cancellation or termination of their licenses, and so Mars' response was to... What was Mars' response?
Well, the response ultimately was, as was demonstrated by the filing, to go all in.
So they filed a motion for injunction.
Okay. There's the complaint itself, which initiates the litigation. This particular litigation, as I pointed out earlier, was for declaratory relief, where you simply go to the court and say, Your Honor, we want, as a matter of law, for you to interpret this contract. And you just set forth the arguments that Joel presented on behalf of Mars and I presented on behalf of Oracle, in order to assure procedurally that all this got in front of the judge, not on a normal trial calendar, which can push things out months before you even have a substantive hearing. We filed what's called a motion for preliminary injunction. And that's just basically a way to go to the judge and say, this is not just like any other dispute. There are exigent circumstances here, which we respectfully ask the court to deal with right away. So in other words, it's measured not in months, but in days, so we could get all these issues in front of the court as quickly as possible.
So Joel said that Mars had more than 250,000 pages of documents that they provided. How many pages did Oracle provide?
Well, obviously, if we're not remembering, we weren't overwhelmed by it, okay? I can't give a number, can you?
Oh, well, I mean, during the...
Did Oracle make an argument on their behalf to say, no, this is really why we took the position we did?
Oh, no. The matter, we procedurally set it up. It's almost like if let's say a sports metaphor. We put the ball, before the football game, you put the ball on the tee, everyone's lined up for the kickoff, the other side's lined up to receive, game over. That's where the game ended.
Okay.
The ball was not kicked. There was not a play. But it was like, we're all set to go. And then someone says, I'm not so sure we want to play this game.
So Mars had the game plan. Mars had the players on the field. And Oracle said...
We'll just say, I'll stay with the sports metaphor and Roberto Duran, no mas.
No mas, okay. Thank you. All right, so beyond Mars versus Oracle, what does the Oracle audit playbook look like? What can you expect when you get audited by Oracle? So this is out of Business Insider a couple of years ago. You can go look up this article. It's kind of fun. I felt like we were being extorted. Customer says Oracle tried to strong-arm him into a cloud sale. So this is one of the typical Oracle audit practices. To Oracle, an audit is not a compliance exercise. It appears to be a sales opportunity. So they're not really trying to say, oh, you're in compliance, thank you very much, we'll see you next time. They're trying to create opportunities for you to pay them money. And that's what they're using the leverage of an audit to generate sales opportunities. So the audit playbook, this is kind of the events that happen is so the things that are kind of happening here. I'll let Art kind of address what's going on with different stages in the audit.
Now we're trying to give you a flavor of the multitude of matters that Joel and I have handled adverse to Oracle as it relates to these licensing practices. What occurs, and so we're applying a more general look to give you an idea as to what appears to be recurring here. And the Oracle issues an audit report, and almost without fail, it finds an extreme licensing deficiency by a factor sometimes of 50 to 100. And you can imagine what that does to your typical CFO when he or she has to go back to the CEO or the board and say, well, actually, we had the line item for, let's say, $1 million in terms of fees related to the licensing of the Oracle product. As it turns out, after this audit, it's more like $100 million. That shortfall, of course, getting back to this new technology, is all predicated on the use of the virtualization software. And we've provided here the language, again, from publicly available documents. Oracle programs are installed on any processors where the programs are, again, available for use. Third-party VMware technology specifically is designed for the purpose of allowing live migration of programs to all processors across the entire environment. The idea, of course, being it's theoretical, and therefore that's enough. And then
and that's not a valid argument. That's just the argument that Oracle has been attempting
absolutely,
to make.
yeah. To understand, this is Oracle's playbook. Exactly. Then there's the at times onerous demand that the matter be resolved within 30 days, which, when you're looking at a shortfall approaching 9 figures, can be almost staggering.
Yeah.
Then, once the audit report drops, the audit report rarely, if ever, that I have experienced, comes with a dollar value assigned to the shortfall. Ever seen dollars in a
good
license
point.
audit?
They never include dollar values. It's just a count of cores that are deficient.
Right.
When you think about it, and that makes it even more compelling in its own way, because you do the math.
Right. You do your own math,
and it's, oh my God.
Yeah.
Well, right, and it will say, reading the audits is often, it's almost humorous. It'll tell you how many processes there are, then the core factor count, then it'll say, all right, so you have 8 licenses. Now, that's a good start, but it looks like you're going to need 97 in order to keep going. And just the staggering, jaw-dropping moment that comes, then immediately that gets accelerated, it gets sent around internally, because then this, therefore, becomes an issue that must be dealt with. However, who you hear from next is almost always either Oracle sales or licensing management services. And they come and they will calculate up the cost, and they will say, all right, so here's the list price, but of course we're here to help you out. We're here to figure out a way in which we can all continue working together, have our Oracle licenses, and they will offer you, say, for example, a deep discounts, 50, 60, 70, 80% off of that list price. So don't worry, what was going to be, again, pulling a number off my head, the $40 million that it looks like you owed, we're going to drop that down in a special one-time offer. And in fact, with the quarter end, just be sure to sign it by Friday, $2 million. And then we walk away, and you can continue essentially doing what you've already been doing. The deep discount, of course, is always part of the playbook, but an additional part of it, and this in itself could be its own little breakout seminar, is how they play it vis-a-vis cloud credits, or how to try to encourage would be one word, carrot or stick, depending upon where you are in this story, resolve it with purchasing cloud credits, moving onto the cloud, taking your back support and instead of paying what they say you owe in back support by a discounted number of credits that can be used for not on the cloud now, not a big deal. You'll just buy some cloud credits and then you can use them when you're ready to come onto the cloud. It becomes the car wash tokens that you find inside of your pocket 6 months after the car wash had closed down.
Only you're getting cleaned out.
Yeah. Exactly. While you were finding the lint in your pocket, you find out that we won't take that analogy that much further. In the beginning, we always had heard that a lot of what that push was for was because cloud credit, cloud sales had an unusually high commission for the people who were selling. And I believe that to still be the case from what I have heard. But I think that it does go a little bit richer and deeper than that, which is that Oracle is making a play to become a competitor in the world of cloud hosting. You have AWS, you have Google Web Hosting, and then you have Oracle who's trying to work their way into it. And a lot of what we believe is that they are creating an amount of anxiety and an amount of uncertainty that comes with people with where they are now, whether it's on AWS or whether it's just virtualized and they're thinking about going onto the cloud. And this becomes kind of the promise that Oracle offers, which is all this could just go away. Just get off of AWS. Just don't think about Google and all of these hassles that are here now that'll happen 3 years from now when you're audited again. It all goes away if you move onto our cloud. So we have the smaller issue, which is, of course, we think that they are incentivized to sell cloud. But then what we believe to be the larger issue, which is Oracle's play to become a major competitor in the cloud space. They always rely upon, and by always I mean always, on the partitioning policy. And remember back to the slide that Nathan had, which was the series of checklists. You have your two tranches. What is your policy, or what is your license, and then what is everything else? And everything else is a very large bucket, and that includes Oracle's partitioning policy. It's available online. It can be found through a quick search or at this link. But it basically says soft partitioning is not an acceptable method by which you can delimit the number of licenses you need to purchase. And otherwise, you can tell me all you want about how live migration has been disabled, but we call that soft partitioning, and soft partitioning isn't a good way, it's not an effective, it is not a licensed way to decrease the number of licenses that you are responsible for. Now, remember, of course, that on that document itself, it says at the bottom, this is not part of your contract. This is for educational purposes only. However, no matter how much that gets pointed out back to Oracle again, they say, that's our policy. But it's not in the contract. That's our policy. And it just becomes kind of a ping-pong static at that point.
Is there a difference in your experience for making that argument to a sales or an LMS person at Oracle and making that argument to an attorney at Oracle?
Oh, very much. Yeah, all the difference in the world. I mean, frankly,
thank you. What needs to be understood, and the point that Joel has come back to now a couple times, if you're dealing with the salesperson in this scenario, and he or she is bringing up soft partitioning, the appropriate response is, where's that in the contract? You know, what are you talking about, and why are you wasting my time? It has nothing to do with anything. That's what I would call the appropriate and sophisticated response to that. Because at the end of the day, once you engage in that conversation, and all of a sudden you're having a back and forth on partitioning, and then generating written communications, all of a sudden you're creating a record where someone comes along, could be a judge someday, and that person is looking at it and saying, well, you know, some of these communications here, you seem to be acknowledging that partitioning is part of the contract. And candidly, that's why the intervention of counsel and talking to your lawyer about the position they're taking and squaring off that contract and making sure that nothing generated by you in the way of a communication about the license agreement could ever be viewed as interpreting it in a way consonant with what Oracle is presenting. This is a classic situation when you're struggling over the meaning of a document where discipline in your communications with, in this case, Oracle, an potentially, if not actual, adversarial party, is vital. Because you can quite literally, by virtue of communications, be inadvertently rewriting the contract.
Yeah. So we've seen that that Oracle salespeople and LMS will sometimes use the threat of turning you over to the Oracle litigation team as, you know, a means to get you to comply with their demands. We don't think that that's a problem. We much prefer dealing with Oracle legal than sometimes dealing with the Oracle LMS people. So you know, dealing with Oracle legal is actually not that scary of a proposition.
Well, it depends on where you're sitting, but no.
Yeah. All right. So the next slide here.
Well, and this is to, again, as part of, if you will, what we see in general terms evolving in these disputes. There are certain things that emerge consistently with what at least Oracle would like to see when there is resolution of the dispute. One is a declaration of non-migration. This is something that Oracle typically demands, and it's in the form of a certification that there's been some sort of disabling of the live migration. Obviously, clients need to look at that, factor that in, and figure out what that means for their business. There's, of course, the execution of an audit close letter. But of the elements listed here, the thing that is so important and dangerous are the replacement agreements that are tendered at times, if not if you will, pressured by Oracle on the licensee to execute. And the concern here with these replacement agreements is the fact that those contracts which Nathan was describing earlier, where frankly we believe very much you are protected by the language. Oracle actually uses the negotiations and the replacement agreements to get something better. And that's why, of course, it's so important that you receive appropriate counseling, because in one instance, you can be left with a position of vulnerability to allegations of future licensing shortfalls. And then to Joel's point earlier about where what we believe to be the bigger picture here, it could make it more difficult for the licensee to migrate to a cloud hosting environment, unless, of course, that environment be Oracle's.
Yeah.
So just because this is such an important part, and I don't want to get lost in too many of the details, but two of the ways in which they try to do that in replacement agreements involve both the unlimited license agreement. Now, Nathan had talked about that earlier. He called that the EULA. And then another kind of more recent creature we've seen, which is the limited use virtualization license. And both of those can end up in a scenario where one moment you are compliant, at least according to how Oracle says you must be compliant, and then another moment later, you are not. So for example, with a limited use virtualization license, what they often try to peddle is a $0, no cost, all use virtualization license. So recall a audit report comes out and says you are short by 98 licenses, but as long as you buy the cloud credits and do a few other things, we'll give you this limited use virtualization license for these. Therefore, you're compliant and we needn't worry anymore. But remember that the number that they give you is so precisely contoured to your snapshot of your environment at that time that the mere flip of a switch, the opening of a new server, the repartitioning is going to all of a sudden give you another number of licenses, and you have automatically become non-compliant, at least by Oracle's argument. But the problem is that you have accepted what their argument is. And so they say installed and or running, they say you need licenses for everything virtualized, you accept a precise number of licenses, and then 3 weeks later somebody sneezes and you need 9 more. All of a sudden you're not just non-compliant, you are non-compliant in an environment you have agreed to. And it is much harder to bail yourself out under that situation. Similarly are the unlimited license agreements, where it sounds like a good deal. You purchase it, you're good to go for the duration of the unlimited license agreement. No one's going to count any licenses. Maybe you're paying a little bit too much, but you can always pay more for sound mind. But then comes the moment where it ends, and per the terms of the EULA, and these are all some very good sample ones are available online, you need to certify off of it. When you certify off of a EULA, remember the talismanic phrase installed and or running magically changes to installed and running. So you are compliant for 1 minute, because everything that was installed and or running is properly licensed. But when you certify off, you do a license count for how many you are using that then transfers into that becomes your license count. It's no longer installed and or running. It is just installed and running. So the entire delta, the difference between what is running and then what is virtualized and what is therefore installed by Oracle's argument, that delta then magnifies itself and you are automatically compliant the moment that you certify off of a EULA. So that goes back to Art's point that these are all solutions that are good for one moment, but then when something changes, either you certify off the EULA or your virtualized environment changes even modestly, you have accepted something and then you've become non-compliant by your own terms. So it is always very, very important to analyze and think hard about what the vehicle is that you use in order to close the audit. Those are two examples, but two very important and crucial examples to think about because they are ways in which you buy yourself peace of mind for a year and a half, and then you're worse off than you were before you started.
Thanks, Joel. And we're running a little bit short on time, and I want to leave a minute or two for a question at the end. But so I'll go past some things here. This just illustrates here the magnitude of Oracle's claims. Well, this is a typical customer where Oracle claimed hundreds of millions of dollars of compliance, and they said, well, but we'll be nice and we'll negotiate only at tens of millions of dollars. Where House of Brick worked with them in defending this audit and found that their actual compliance was tens of thousands of dollars. You can see the delta of what some of these claims are and what's true. So preparing for, just very quickly, how do you prepare for an Oracle audit? One, involve legal counsel early. If you haven't already gotten that impression by the great things that Art and Joel have said today, involve legal counsel early. Involve your own legal counsel early in your inside counsel. If you have a general counsel or somebody in-house, involve them early. Don't respond to Oracle without getting your attorney involved. Understand what your contractual rights are, what's in the agreement, what is not. Be vigilant, ensure architectural integrity, and monitor regularly to make sure you're staying compliant. We recommend a routine annual internal audit to make sure that you're staying compliant according to your contract. Don't panic. You have 45 days. We've seen customers that get the audit notice and immediately they're telling Oracle everything that they know because they don't want to be viewed as intruding in Oracle's demands. You have 45 days. Just sit back, take a breath, don't worry, give us a call, get your attorney involved, and don't over-communicate. That may be a very, very important thing. Don't tell Oracle things that they don't need to know. They'll ask about your whole VMware environment. You only have to tell them about where Oracle's installed and or running, not the whole rest of your VMware environment.
What if pizza's involved?
What if pizza is involved? Train your DBAs. DBAs are kind of pizza wired, so, tell your DBAs, hey, if Oracle shows up with pizza, there's probably, it's probably like a covert operation. Keep a written record. So we recommend that you do all audit communications in writing. You don't take meetings, you don't do phone calls, you do it all in writing.
Well, and while doing it in writing, make sure that you are thinking and planning and putting together written communications that you can stand by. That often involves working with your technology people and your counsel.
Right.
Those are not willy-nilly communications because you're going to stand or fall based on the communications that are generated during the
Right. So scrutinize the findings. Like I said, we've never seen a report that was accurate the first time. So go through the details and scrutinize that report to make sure that it's accurate. Don't be intimidated and know your position and stand your ground. So those are our recommendations for how to deal with an audit. Some services that we provide, we can help you. We can help you defend yourself against an audit. Like I said, we're working with Art and Joel on a daily basis with many different customers, helping to defend themselves against an audit from Oracle. House of Brick has a managed license support service that is an annual fee for unlimited audit defense. So we can help either a little or a lot, but don't feel like you don't have any help out there. We can help. And then Art and Joel, services.
Well, at the end of the day, as trial lawyers, we can say if that all just goes down the toilet and it ends up in litigation, so be it. Just make sure that you're in the best best position possible based on the discipline that you have in the communications with Oracle, and that you know and are confident in the written record that's going to go to the court, because most likely with this form of dispute, to the points we were making earlier about written words, and they were put on a page years ago, and now someone's got to figure out what they mean. If you have controlled the generation of the record, you're going to be in the best position to protect your interests.
All right. We have less than a minute now. Is there one question? We'll take one question, and then we'll go out in the hall. If you want to ask us some more questions, we'll be out there and talk to you.
So in the big theme here is VMware Cloud and AWS. Big difference is, opposed to shared infrastructure that you could not understand physical processors, now there's 144 physical processors running VMware Cloud and AWS. And I guess I calculated that if you move, say, an OBIE, Oracle Business Intelligence Enterprise Edition, $300,000 per CPU core, that would be $43 million prior to discount.
So there's a couple of blog posts out on houseofbrick.com. If you go to the blog, a couple of blog posts about how to license in the cloud, including VMware Cloud on AWS. And so go take a look at that, and it explains some detail. Basically, you have to pick your licensing model. You either pick Oracle's AWS model, or you have to go with dedicated servers.
But does Oracle's AWS model that was designed for AWS prior to VMware Cloud and AWS, does that also apply to VMware Cloud and AWS?
That's a question that I can't answer, that you need to talk to your attorney about. The Oracle's statement says that in order to qualify for VMware Cloud, for Oracle on AWS, it says AWS, EC2, and RDS. So is VMware Cloud on AWS EC2 or RDS? I don't know. So that's the question that needs to be answered.
Thank you.
Thank you very much.
All right. Thanks, everybody.